Good afternoon, everyone, and welcome to the Committee for Justice's virtual panel discussion, the Supreme Court and LGBT rights, textualism, or judicial activism. I'm your host, Ashley Baker, and I'm the Director of Public Policy at the Committee for Justice. So today we have a group of really exciting panelists with us who I'm sure are going to have some excellent insight on the Supreme Court's controversial recent Title VII decision. And I'm going to go ahead and introduce the three panelists in the order in which they are going to be speaking. First, we have Curt Levey, who is president of the Committee for Justice and is a veteran of Supreme Court confirmation battles. After graduating Harvard Law School with honors in clerking for the U.S. Court of Appeals for the Sixth Circuit, Mr. Levey served as the Director of Legal and Public Affairs for the Center for Individual Rights. There, he worked on landmark Supreme Court cases, including the University of Michigan affirmative action case and the successful constitutional challenge to the Violence Against Women Act. After CIR, Levey headed to the Title IX policy group at the U.S. Department of Education's Office for Civil Rights. Levey is also a longtime member of the Federal Society's Civil Rights Executive Committee. Before attending law school, Mr. Levey earned undergraduate and graduate degrees in computer science from Brown University and worked in the field of artificial intelligence. Edward Whelan is the president of the Ethics and Public Policy Center. He directs EPPC's program on the Constitution, the courts, and the culture. His areas of expertise include constitutional law and the judicial confirmation process. As a contributor to National Review's online bench memos blog, he has been a leading commentator on the nominations to the Supreme Court and the lower courts and on issues of constitutional law. He has written essays and op-eds for leading newspapers, journals, and law reviews. Mr. Whelan is co-editor of Scalia Speaks, Reflections on Law, Faith, and Life Well Lived, a New York Times best-selling collection of speeches by Supreme Court Justice Antonin Scalia, and of On Faith, Lesson from an American Believer, a collection of Justice Scalia's writing on faith and religion. Mr. Whelan, a lawyer and former clerk to Justice Scalia, has served in positions of responsibility in all three branches of the federal government. From just before the terrorist attacks of September 11, 2001, until joining EPPC in 2004, Mr. Whelan was the Principal Deputy Assistant Attorney General for the Office of Legal Counsel in the U.S. Department of Justice. In that capacity, he advised the White House Counsel's Office, the AG, and other senior DOJ officials and departments and agencies throughout the executive branch on difficult and sensitive legal questions. Mr. Whelan previously served on Capitol Hill as General Counsel to the Senate Judiciary Committee. In addition to clerking for Justice Scalia, he was a law clerk to Judge J. Clifford Wallace of the Ninth Circuit. And our third panelist is Alison Somin, who is a legal fellow with the Pacific Legal Foundation. One disclaimer, however, I'd like to point out that Ms. Somin is speaking on her personal capacity and not in the capacity of the Pacific Legal Foundation as an organization. Somin joined PLF in May 2020 as a legal fellow for the Center for the Separation of Powers, and she is also part of the Equality Before the Law Practice Group. Previously, Alison was a special assistant and counsel for over a decade to Gail Harriet, a member of the bipartisan United States Commission on Civil Rights. She also has deep roots in the liberty movement. Alison was a Koch associate at the National Federation for Independent Business Legal Foundation and, during law school, completed summer clerkships at the Institute for Justice and the Charles G. Koch Charitable Foundation. She holds a JD from Emory University School of Law and AB in History from Dartmouth College. Her work has been published in the San Francisco Chronicle, the Daily Journal, Texas Journal of Law and Politics, and the Federal Society's Engage magazine and blog. A couple of quick housekeeping notes for those of you who have questions, which I'm sure there will be many given the topic today. If you could please send me the questions through the Q&A function on Zoom. Just type them in, those are sent directly to me. You can send those at any point during the panel. It doesn't have to be during the Q&A section. Once we get into the discussion segment, I will later bring up your questions whenever they arise. So feel free to send those in to me whenever. And with that, Curt, the floor is yours.
Thank you, Ashley. So today's panel is about the Bostock decision in which the Supreme Court interpreted Title VII, the landmark 1964 law banning employment discrimination, interpreted to encompass discrimination based on sexual orientation or gender identity. There are actually three cases involved, but one set of opinions. Gorsuch wrote the majority opinion. I think a few years ago, the idea that Title VII covered LGBT discrimination would have been shocking. And in fact, in till a few years ago, every court of appeals that had addressed it saw the other way. But, with the Obergefell decision in 2015 and changing public opinion, I think people realized, these cases could go either way. Now, of course, public opinion shouldn't matter in statutory or constitutional interpretation, but it does. Gorsuch certainly didn't see anything controversial about these decisions. He said he was doing nothing more than interpreting the text of Title VII. And to be fair, he does focus on textual analysis. It's just that his analysis is strained, and he seems to be reaching for a particular result, although, of course, we can't get inside his head. I think this opinion would be easy to dismiss as just another example of, politics masquerading as interpretation if it was written by one of the court's liberals or even by Chief Justice Roberts. But it deserves to be given more serious consideration, given that Gorsuch has been a principal textualist. But I think even if you do give him the benefit of the doubt, you still have to come to the conclusion that his analysis is flawed. So let me get into the details of what he said. The case hinges on Title VII's command that it is unlawful for an employer to discriminate against any individual because of such individual's race, color, religion, sex, or national origin. And the key here is that that list does not include sex orientation and gender identity. But Gorsuch reasons that discrimination based on those characteristics is really discrimination based on sex, because, and he gives an example that a man who is attracted to men might be fired by an employer who is hostile to homosexuality, whereas a woman who is also attracted to men would not be fired. But that's a stretch, and there are holes in the reasoning. I mean, one example that I thought of is, imagine an employer who posts a no gays or lesbians hired sign at the company's front door. That person wouldn't even know the sex of the potential applicants he's scaring away. So how would that be discrimination based on sex? Now, again, Gorsuch's reading of the text is not crazy. It's not completely indefensible, but it's certainly not the most natural reading. And even if we give Gorsuch the benefit of the doubt, he still runs into the problem that his interpretation is completely at odds with the legislative intent. Not even the plaintiffs, who brought these cases, claimed that, anyone in Congress intended the statutory text to reach sexual orientation and gender identity. Now Gorsuch is correct that legislative history should never trump unambiguous statutory text, but his claim that there's no ambiguity here and that the answer is clear, to quote his words, strains credulity. As I pointed out, it certainly wasn't clear to the lower courts. Were the text as clear as Gorsuch imagines it to be, all the bills that have been introduced over the last 45 years into Congress to protect gays and more recently transgender Americans from employment discrimination, would have been redundant. But I remember the advocates for those bills when they were testifying for it, and they all said that Title VII needed amending to prohibit this type of discrimination. In some sense, the irony here is that, with public opinion rapidly changing, Congress likely would have extended Title VII to LGBT discrimination in the near future. And then it would have had, the imprimatur of bipartisan support. Instead, it really has the taint of being imposed by unelected judges. And then, another problem when courts impose these things is that, Congress can deal with detailed policy compromises, but courts can't. So we're left with a bunch of difficult questions that were not addressed, like the legality of sex-segregated bathrooms, the accommodation of employers' religious convictions. I saw an article in a higher ed publication that said this could transform Title IX, i.e. not just Title VII. If so, we'd have more difficult questions like men on women's teams. I suppose that question even now could arise under Title VII if we're talking about professional teams. And Gorsuch said, don't worry, these are questions for future cases. So yeah, it's put off for now, but it's sure to cause divisive battles, precisely because they haven't been addressed. I guess if you're looking for a silver lining, I guess it's that Gorsuch did engage in textual analysis. It's certainly better than what we probably would have gotten a few years ago, where Kennedy probably would have written the opinion and, would have said something about the right to define one's own concept of existence, as he did in Casey, for example. But remember, when Kagan said we're all textualists now, there might be some truth to that, in that judges not all, but many judges feel at least the need to do textual analysis, but that doesn't mean that textual analysis won't be flawed or even disingenuous. So conservatives are quite upset with Gorsuch. Should they be? Well, not because of the outcome, not because Title VII has been expanded. The evaluation of judicial decisions based on policy preferences is a practice of progressives that I don't think conservatives should copy. Concerns that Gorsuch has abandoned principal textualism in exchange for let's say popular press. I think that's more tenable, but I think it's premature. Bostock is only one decision, and if you look at today's DACA decision, Gorsuch didn't join Roberts and the liberals. So again, remember, you can be principled and wrong. Those are not mutually exclusive. And let me just conclude with one thought, which is, let's not let all the Gorsuch bashing I've heard in a few days obscure the fact that Roberts once again sided with the courts for liberals. He's certainly making a habit of it. We had DACA today, and just in the last 12 months, we had the very similar census decision, the New York gun case, our deference to the administrative state. If he wasn't already, he's now firmly established as a moderate at best. Certainly a swing vote up for grabs. So next time you hear Democrats screaming about the Supreme Court, being right wing and threatening to restructure the court, as Senator Whitehouse said, remember that there are at least as many reliable liberals on the court as there are conservatives. And final thought, for conservatives unhappy about this decision, maybe that's a silver lining. The fact that, with Roberts and Gorsuch siding with the liberals, this really does put the lie to any idea that this is a right-wing court. So I'll stop there.
Now I'd like to head the floor over to Ed.
Well, I thank Curt for that presentation. I must say I disagree with him on the import of this decision. I think it is a terrible decision legally. I think it will have horrible, in many ways, completely unforeseen consequences for years and years. And I think conservatives are entitled to be livid about it. I'm going to start by reviewing briefly the dissents in this case. Justice Alito wrote a long dissent joined by Justice Thomas. Justice Kavanaugh wrote a somewhat shorter dissent. I think the two dissents are compatible. Pardon me. Sorry, the phone rang here. But they have their differences as well. Alito memorably describes the Gorsuch opinion as being like a pirate ship sailing under a textualist flag, when what it actually represents is a theory of statutory interpretation that Justice Scalia excoriated. And I think he's entirely right on that. He calls the opinion preposterous. At one point, he compares the textual analysis that Justice Gorsuch undertakes as something you'd expect from an alien. And he says, textualists do not read statutes as if they were messages picked up by a powerful radio telescope from a distant and unknown civilization. So I think what you see in both the Alito and the Kavanaugh dissents is an emphasis on ordinary meaning, not wordplay, not what sort of literal or hyperliteral meaning can we stitch together if we're really creative, but what was the ordinary meaning that this provision had when it was enacted in 1964? Now, Justice Gorsuch tries to dismiss that as subjective expectations. I don't think that's fair. I think Alito makes a compelling case that no reasonable American would have understood this in 1964 to cover sexual orientation or gender identity. He points out, among other things, that he says, while it's painful to be reminded of the way our society once treated gays and lesbians, the plain truth is that in 1964, homosexuality was thought to be a mental disorder. And he says, we must therefore ask whether ordinary Americans back then would have thought that discrimination because of sex carried some exotic meaning under which private sector employers would be prohibited from engaging in a practice that represented the official policy of the federal government with respect to its own employees. And as he says, the question answers itself. Likewise, with respect to transgender status, he says people have been scratching their heads over what that even means. Now, another objection I have to Justice Gorsuch's opinion is that it makes no attempt to harmonize his holding with long settled practices that have been approved by the courts throughout the country. I speak specifically of dress codes for employees and appearance standards. One can also look to sex-specific restrooms, shower facilities, etc. But every court of appeals to address the issue, even the Ninth Circuit in en banc opinion, has said that these sex-specific dress codes are fine so long as they don't unduly burden one's sex. But they cannot survive the analysis that Justice Gorsuch engages in. And he says, oh, that case isn't before us. Well, I really think he has an obligation to think hard about how his approach could possibly allow these long settled practices. And the fact that it doesn't, I think, is a big strike against it. Both he and Justice Kavanaugh, as Justice Alito and Justice Kavanaugh, discuss how textualism has always turned on ordinary meaning. There are indeed quotes from Justice Gorsuch in other cases or in others of his writings that reflect the same principle, but I think he's completely abandoned that here. I'm not going to psychologize on why. I hope this is just a terrible one-off. But it is terrible, and whether it's the abolition of women's sports, gosh, one liberal was positing the other day that you're going to be, that some years from now, you'll be subject to dismissal from a college if you discover that you are not happy with the surprise sexual organs of the person you're dating. There could be all sorts of strange consequences from this. I want to comment briefly on the Chief's vote in this case, which I think surprised a lot of people. I confess it surprised me. And those who were at oral argument and saw how skeptical the Chief was of the position they ended up embracing, I think are even more surprised. By the way, Gorsuch at oral argument called this a close question. In his opinion, he says, "Oh no, this is simple. This is not no issue at all here." So I think he's being I think it's a very sophistical opinion. But the Chief's vote is curious in two respects. One is the Chief wrote a very powerful dissent in Obergefell, the same-sex marriage case. In that dissent, he did not address the claim made by many that laws that define yet under the approach he's adopted now, I think he would have been obligated to explain why that wasn't a winning argument. Again, there could have been answers to that. But the fact that he didn't even address it, the fact that no one addressed it, I think makes it far-fetched that we now have this view. Some people presume that Roberts assigned the opinion to Gorsuch in the first place, that Roberts was part of the six-justice majority from the beginning. Maybe, who knows? I'm skeptical of that. I would think if the Chief were part of the majority, he would have assigned the opinion to himself. I wonder, switch. and I wonder if there are some sort of broader institutional reasons that would justify it. Let me finish with one point. There's a subject of a post of mine today. This isn't a silver lining, but I think it highlights some of the incoherence of the opinion. I explained that the Bostock majority is really, it rejects the proposition that a so-called trans woman really is a woman. This, of course, is the major claim that transgender ideologues make, and you see a lot of the transgender-friendly rhetoric in Gorsuch's opinion. But in the end, for all the faults of his opinion, it's predicated on the proposition that a man who identifies as a woman is in fact a man, and it's because of that that it's in Gorsuch's view discrimination on the basis of sex to treat a man who identifies as a woman differently from a woman. If the man who identified as a woman were in fact a woman, it wouldn't be sex discrimination to treat him differently from other women. Likewise, I think the opinion actually builds on the dreaded gender binary. That it's difficult to see how Gorsuch's logic would apply to the dozens of other genders that are said to exist. Again, while I think his logic is wrong, it clearly applies to a man who IDs as a woman and a woman who IDs as a man. But if you have someone who identifies as genderqueer or pangender or agender or gender fluid, an employer who decides not to hire any such person obviously isn't treating men any differently from women and therefore isn't engaged in sex discrimination. Similarly, I don't think the reasoning of the argument extends to bisexuals. But in any event, I'll leave it there for further discussion. Thank you.
And I'll now turn it over to Alison.
Okay, thank you. Curt asked me to focus on the future implications of this decision, which I think both of the previous panelists have alluded to, but which I hope to discuss more fully. One interesting question is to compare how all of this will play out to the various bills that have been proposed in front of Congress that would have created an employment discrimination regime that would apply to LGBT persons. So first of all, there's the issue of bona fide occupational qualification. Within Title VII, if is a bona fide occupational qualification, an employer may in fact discriminate on the basis of sex. I think in some versions of legislation that have been proposed, there would not have been any such bona fide occupational qualification. I think it therefore follows logically that there would in fact be a bona fide occupational qualification defense in cases involving sexual orientation or gender identity. Under Title VII, there's also a rule that disparate impact, meaning that if an employment practice or procedure has a disparate impact on a particular sex, even if that practice is completely facially neutral, even if the employer doesn't intend to discriminate, it may nonetheless be illegal unless there's a business necessity for the defense. This is quite far-reaching, restricts employers' freedom considerably, and is something that I've expressed skepticism and constitutional concern about in other fora. If gender identity and sexual orientation are equated with sex, then I think that this would also expand disparate impact to sexual orientation and gender identity. Again, in some versions of anti-discrimination legislation that have been put before Congress, they have been clear that they are disparate treatment only and would not create any kind of disparate impact claim. One thing that's been discussed frequently is to what extent religious employers have any kind of defense to claims of discrimination against sexual orientation and gender identity. Title VII contains some protection for employers that are themselves houses of worship, but that generally doesn't extend to employers who are individually religious but engaged in more conventional kinds of private business, such as restaurants, carpentry business, what have you, that are owned by Christian families. employees. The Religious Freedom Restoration Act does give exemptions from laws of general applicability in cases where a person's exercise of religion is burdened. I think in at least some circumstances, there's a pretty good case that that such employers would be exempt from Title VII. Gorsuch alludes to this himself in his opinion, but because the terms of the statute are broad, until this is actually litigated, I don't think anybody can say they know for sure. Many employers are rationally risk averse and therefore may not want to risk it. May find that it's just more in their interest to employ somebody or what have you in these cases. I think it's. By the way, the most recent version of the Equality Act also contained a statutory bar to Religious Freedom Restoration Act claims. So religious employers are probably better off now than they would be had Congress in fact put that version of the Equality Act into law. One interesting question is whether also employers and others have a positive duty to accommodate the preferences of LGBT employees, such as whether to use their preferred pronouns, the preferred choice of bathrooms, etc. I think that just a rule of simple non-discrimination doesn't get you all the way to a duty to accommodate these preferences. I think that goes beyond simple non-discrimination. Again, though, I think there are people who will argue that it does, and this will be litigated in the courts. I should also note that this has implications beyond just the Title VII contest. Title VII relates only to discrimination in employment, but there are lots of other provisions of the United States Code that prohibit discrimination based on sex, and I think it's very difficult to say that those somehow don't reach such sexual orientation and gender identity under this decision, whereas Title VII does. The Education Department administers a statute that prohibits sex discrimination by recipients of federal funding in education. The Obama administration issued various guidance interpreting that statute to cover sexual orientation, gender identity discrimination, which have been rescinded by this administration. I don't see how under this decision Title IX gets interpreted differently, and so you may see some elements of that interpretive regime coming back. The agency that I'm less familiar with, Health and Human Services, also has statutes that prohibit discrimination on the basis of sex by organizations that receive funding from them. Once again, I expect that it's going to be very difficult to read their statute differently with regard to sexual orientation, gender identity than Title VII. I don't see how one does it. In terms of how this will play out in employment, I've seen some assertions that there will be lots of litigation, etc., by disappointed employees. That's some risk, and I don't envy employers who wind up in those circumstances. That said, I think that this has been an area where especially large employers have adopted non-discrimination policies and are unlikely to want to discriminate in hiring promotion against LGBT persons. Gary Becker famously wrote a piece about how many employers lack what he called the taste for discrimination. When it comes down to it, they tend to prefer people who are competent, who will make the money, rather than focus on these other characteristics. Where I think there'll be more of a practical effect on employers is in the area of compliance and training. The way that hostile environment harassment case law has developed in the sex and other contexts, it's hard to know where the line is when harassment becomes sufficiently severe and pervasive that an employer has violated the law. So employers essentially have an incentive to crack down on even very mild conduct in jokes, etc., involving sex. And so I think that you'll see more of an effort by employers to stop even relatively mild banter involving sexual orientation, gender identity, even debates about contentious political or other issues, again, because rational risk-averse employers don't want to get anywhere near this line. And so I do expect to see a sort of the growth of politically correct ideology within the workplace, chilling kinds of conversations or jokes that could get employers close to the line for harassment, as you've seen in other areas regarding sex and so forth. I think that's all I had, so I look forward to questions.
Great. Thank you, Allison. To start the discussion, why don't we take a step back a little bit? I know there was a lot of reaction actually at the time of oral argument in this case, and some speculation that Gorsuch might indeed make this decision one way or another, although that's always speculation. What exactly, were there any tea leaves there? I mean, it doesn't seem like he necessarily entirely changed his opinion between the argument and now. And also, does this mean anything for like future litigants? Did the plaintiffs, target specifically Gorsuch, and will he become, the Kennedy, the next person on the bench that litigants try to appeal to?
Well, it was said that that some of the litigants did target Gorsuch. Again, I don't really know what was in their mind. Just because he was a textualist. And the best argument that the plaintiffs had, again, I think we all agree it wasn't a good argument, but the best argument they had was a sort of hyperliteral reading of the text. So I guess, one lesson future litigants might learn is, if you have a hyperliteral textualist argument, target Gorsuch, although again, I don't think we really know why Gorsuch did what he did, whether it was because he really did believe in this, hyperliteral interpretation, or whether it's, because he had some larger goal that he was trying to reach. So I'll stop there and let the other panelists weigh in on that.
If I may, we've already had a cottage industry of liberals doing what they can to co-opt originalism, and in this case, textualism, trying to pick off a justice or two. I don't think they needed to have anyone in particular in mind. Of course, what we see is that the liberal justices pretty much march in lockstep in major cases. You had, at least in the instance of Sotomayor, Breyer, and Ginsburg, justices signing on to principles of textualism that they manifestly do not believe, and ignoring arguments about consequences that and legislative purpose that supposedly govern them. So what we have is a situation in which there is this solid block on the left that simply needs to pick off one or two, one of the Republican appointees, and they have, in different cases, several candidates to choose from. And, I think, for better or worse, that helps explain why we're in the situation we're in. I think the liberals largely vote. Well, I was going to say they largely vote politically. I guess you could just say the judicial ideology doesn't distinguish between law and politics. So, and you have, conservatives who, in some cases, embrace, or if you prefer, fall for some of these textualist or pseudo-textualist arguments.
I think it's also notable how there were no concurring opinions from the left too. I mean, do you think that they, perhaps were afraid of losing Gorsuch, or is that just as simple as them, tacking on and using, textualism to their advantage whenever it's there, as they sometimes do?
Justice Ginsburg explained back in Obergefell, I think, when the same question was raised, like, why would they sign on to this opinion full of blather? It doesn't really reflect their best understanding of things. She just says, we're going to sign on so we don't lose or alienate Justice Kennedy. Well, I think it's the same thing here. Again, they have shown that they will sign on to whoever reaches the result they want. Now, of course, justices give some leeway to the writing justice. No one expects that that an opinion written by someone else is going to be exactly the way you put it. But that's very different from embracing propositions or methodologies that you don't agree with.
Yeah, I think the liberals on the court were only too happy to have Gorsuch, write the opinion because it gave it more credence. And so, why get in his way by writing concurrences, which is also, by the way, why I don't agree with the theory that, some people have said that Roberts became the sixth vote because he wanted to be in the majority so he could assign it to Gorsuch, because otherwise Ginsburg would have done the assigning. But again, I think if Ginsburg was smart, she would have given it to Gorsuch anyway, because it just gives this way more credence than it otherwise would have had.
And while we're talking about the alignment of the justices, one of my initial thoughts in seeing this that I haven't really seen anyone discuss is just how terribly unpersuasive Justice Alito was in his opinion in persuading the rest of the court. Do you guys have any thoughts on that?
Well, I'm not quite sure what you mean. Look, the way Supreme Court opinions are written, folks tend to be locked in when a majority opinion circulates. Perhaps things have changed, but back when I clerked, it was embarrassing to see people sign on to 85-page opinions within 3 minutes of the time they were sent around. Once you have folks locked in, you're not going to get them to change. Again, it's possible that as Curt and I have speculated, that the chief may have changed his vote late for who knows what reason. It certainly wouldn't be for lack of persuasive force in the Alito opinion. I would have preferred that Justice Kavanaugh just signed on to the Alito opinion. I don't know what he. I think he wrote a very good dissent, but I'm not quite sure that having two different dissents out there is really worth it when they're largely compatible.
Yeah, I suppose I meant really his reasoning, not the opinion itself, the process. I just expected a lot more support.
By the way, I agree with that. Normally when there's multiple dissents, they sort of each take a different tack, and here they read quite similarly. So, I was also left with the feeling of, why not just have one dissent joined by three justices? Ed's certainly right that, and again, especially when it comes to the four liberals on the court, they're not going to be persuaded by anything Alito says, even if it was the most brilliant dissent ever written. The only justice that really seems to switch at the last minute is Roberts, and we can only speculate as to why he sometimes does that.
I was about to say, I think you meant the five liberals in the court.
Perhaps, yes, after today.
Obviously there's a lot of pretty vehement outrage at Gorsuch, and I agree with Ed to the extent that they should be. I think they should also be outraged for, the right reasons, because the analysis is incorrect. What do all of you, make of the essentially just blatant calls for conservative judicial activism that we are now seeing from some on the right?
Well, I don't think it's, new. There's always been, I'd like to think that within the conservative legal community, most of us are not results oriented, but among the, sort of the conservative base, and these days one might call them the populist base. I think there's always been a desire to get the result right, which of course is judicial activism. I thought you were going to sort of ask about the comments that some people have made. Again, I think an overreaction, saying this is the end of the conservative legal movement. I think Senator Hawley said that. That's an overreaction. And again, if the conservative legal movement has failed, Roberts was a much bigger failure than Gorsuch. But again, I don't think Gorsuch was a failure. I think we all agree that for now it's a one-off, and we'll see what happens.
Well, I'm surprised that some folks are reacting as they are. To say that the opinion gives you some reason to say dump textualism is, I think, to extend Alito's analogy, a bit like saying that, because a pirate ship puts up the American flag, we should get rid of the U.S. Navy. I don't understand the logic. Look, I'm deeply disappointed, as I have been for a long, long time, with what Republican appointments have resulted in. I saw Justice Kennedy, for years. But it's one thing to say that the strategy hasn't been a success. It's another thing to say that there's a better strategy available. The reality is that it's not easy to get a high quality nominee selected or confirmed. There, first of all, are plenty of disagreements among conservatives as to who would count as high quality. But even then, there's a huge political dimension to this. You need to persuade a White House that it's in the political interest of the president to nominate this person, a person whose benefits to the conservative movement are going to come, years after that person has been president. You have to persuade Republican senators that they should be ready to fight to get someone confirmed. And that's not something that Republican senators are generally interested in. And that's true of conservatives as well. They want something easy. They want a coronation. For years you had the 60-vote cloture rule that was rarely invoked, but certainly with Alito as the first time, made things challenging. And when the task was to pick Justice Scalia's successor, that rule was still in place. So there's plenty of reason to be very disappointed and to try to diagnose what's gone wrong. But folks who are saying, oh, the Federalist Society has done something terrible, or we need to abandon originalism and textualism, for what? Are we going to have Catholic integralists forming political majorities in this country and getting folks confirmed to with a stated mission of imposing Catholic social teaching? It's absurd, and it's for good reason.
I did not agree anymore. Oh, sorry. Go ahead.
As Ed points out, if the nomination and confirmation process consisted of one of the three panelists selecting the nominee all on their own, maybe we would get better picks. Although even then, who knows? You don't know how people are going to be affected by all the pressures of being on the court. But the job of the people who do the picking is to pick someone who can be confirmed. And as Ed pointed out, also there's political considerations. So again, I think we probably all agree that the conservative legal movement has failed. I mean, at least this is not even Roberts is not a Souter or a Stevens. Certainly not a Brennan or a Warren. So that's what we got before the conservative legal movement. So consider that.
Alison, I think I accidentally cut you off.
No.
Okay, sorry. I guess that was Curt. Yes, I was disappointed as well, and also disappointed in that those who are saying this is the end of the conservative legal movement, particularly senators. I mean, not as if senators aren't already prone to hyperbole, but they're saying it's the end because we should be giving these judges a roving mandate, essentially. And abandon the textualism. It's not that they're saying that it's the end of a movement because the analysis is wrong or the analysis wasn't, what they would have preferred. It's it's a lot more fundamental than that. And I think that's really significant and also really disappointing because that roving mandate is going to inevitably lead to some really, really bad outcomes that they're not going to like either. I think we have quite a few questions. I'm going to start bringing in some of these. A lot of these questions overlap and we're not going to be able to get to all of them. So one of them is, let's see here. Do you see the reasoning in this decision will have any impact on the ERA ratification process?
The ERA, yeah, I'm not sure how the legal reasoning in here would affect something that's inherently political. And I won't get into all the details with the ERA, but arguably it's already past the expiration date. Also I would question how much we need the ERA right now. I mean, talking about judicial activism, the American people defeated the ERA decades ago by not giving it the 3/4 of the state's ratification that it needed. And the Supreme Court just went ahead and pretty much read it into the Equal Protection Clause, starting, mostly in the 80s. So I don't even get why we need the ERA at this point.
There are two separate questions, I think, with respect to the ERA. One is, as Curt pointed out, concerns the ERA that was proposed in, I believe, 1972. and that expired decades ago, but there are these claims being made now in some court cases that in fact somehow it was extended and somehow this ERA has been ratified and should be certified as part of the Constitution. Seems to me crazy that that claim will succeed. I don't think that claim is particularly affected in any way by Bostock. But again, some people, including Justice Ginsburg, have recognized, no, we need to start all over again because the earlier effort failed. And I think because I think some folks may figure, well, look, why do we need to start all over? We're getting all the results we want out of the courts anyway. And also, of course, all the things that Phyllis Schlafly said would happen and that everyone dismissed as absurd are happening anyway. So I don't think the ERA will be a major part of our political future, but perhaps I'm mistaken.
So another question, would you please share your thoughts on how the Bostock decision will impact HHS's final ruling on Section 1557 in the Affordable Care Act?
I'm not that familiar with the litigation, so I don't think I'm in a good position to comment. I'm sorry.
Yeah, was that the religious liberty provision, Ashley?
I suppose so. I don't know. I'm not entirely sure. I just thought I'd give you guys the opportunity to ask a chance.
I mean,
all of it, though.
you know, religious liberty issues weren't addressed in this opinion, and you know, again, on its face, this opinion hinges entirely on the text of Title VII. So, you know, again, on its face, it doesn't spill over into other issues. That said, Gorsuch didn't seem very concerned about the effect this would have on religious liberty. He was, you know, only too happy to you know, leave it for another day. So to the extent that you know, any of these issues, you know, whether it's any of these religious liberty issues, be it Obamacare and contraceptives or gay rights, comes before the court, you know, I guess Gorsuch's opinion isn't a great sign.
There are quite a number of questions here regarding the role of Congress, which I think is, you know, obviously an important part of this equation, or not, or hasn't been a part of this equation. Says, can't Congress correct this by amending Title VII? Why don't conservatives demand this of Congress and make this an issue for elections this year? While they're at it, why don't conservatives demand that Congress strip the court of jurisdiction over stuff like this pursuant to the exceptions clause of Article 3, Section 2? It's not just the court misbehaving, it's Congress abdicating.
Well, of course, Congress could amend Title VII to clarify. That's certainly not going to happen. Certainly not going to happen with a Democratic House. I don't even really think it would happen if Republicans controlled both houses of Congress. You know, I think public opinion was trending in this direction anyway. You know, stripping has been proposed. You know, as a remedy by conservatives for a long time. I don't think conservatives really agree on it. I mean, a lot of constitutionalist conservatives, I don't think like the idea, you know, maybe Ed would disagree. So because conservatives aren't united, I don't think, you know, that's going to happen either. And then there's always constitutional questions about whether the jurisdiction stripping would be upheld.
I mean, if you assume massive political power by beleaguered conservatives, it's easy to imagine lots of things getting done. That's not the reality that we live in. We sure ought to do what we can to change that. I think, you know, Congress has been in many respects very timid, but they've been timid because they don't share, a lot of them don't share conservative beliefs. You know, look, some people would say now with hindsight that Congress should have moved to enact the Employment Non-Discrimination Act. I believe that's its full name, and you know, do this legislatively so you can work out compromises and work things through. You know, that's. I mean, I don't think that's a fair hindsight critique because it assumes that one could have plausibly expected such a ruling. But obviously, you know, if one knew back in 2013 what one knows now, there might well have been greater support for that back then.
Yeah, and again, you know, this was considered a huge long shot until just a few years ago. All 10, you know, as of 2017, as I mentioned, all 10 courts of appeal had unanimously rejected the plaintiff's argument here. So that's 30 judges, on the against the plaintiff's argument, 0-4. So pretty hard to anticipate when these other bills came up, that this was going to happen.
So here's one question that's interesting, and probably the last one that we have time for before, very quick closing remarks. Do you think that the reasoning here could, if challenged, lead the court to overturn the decision in United Steelworkers v. Weber, which allowed limited affirmative action and hiring policies as an exception to Title VII?
Well, look, I see that Cass Sunstein wrote a piece to that effect, but this is not a silver lining. The textualist case against racial preferences under Title VII is straightforward and does not benefit from the sophistical reasoning of Justice Gorsuch. You don't need that. Obviously, there's there's a stare decisis argument that will come into play, but I think that a court that is that seems as timid as it is, I'm not expecting anything like that to happen anytime soon.
Yeah, I mean, Weber is now more than 40 years old. I think we'd probably get a better opinion if it came before the court today. But even Weber isn't being complied with. I mean, even Weber puts limits on employers using the diversity rationale, and those limits are pretty much ignored. I mean, you go to the web page of any Fortune 500 company, and they they're proud of having quotas or something like quotas. So they don't even feel bound by the Weber decision that was put forth by a much more liberal court. I think Ed's right. The current Supreme Court, even with Gorsuch and Kavanaugh added, probably is not going to put its foot down on ending racial preferences.
It's still amazing, though, if you look at it. There's a text of Title VII that says, in adjacent words, you shall not discriminate because of race, sex, or other things. That racial discrimination turns out to be okay when it's in against whites, against in higher education, similar provisions against Asian Americans, and then we have this ban on sex discrimination, which you can't discriminate against males and sex discrimination. It goes both ways there. But suddenly this is metastasized to cover sexual orientation and gender identity. It's amazing how the left has managed to get the courts to embrace this cockamamie construction.
Yeah. Although, again, to be fair, even Weber does not, and Johnson, which involved gender, does not, do not say that you can discriminate to your heart's content against men and women. That's more just a practice, and because it's a practice that so often goes unchallenged, and even bragged about, I think people have the impression that the courts have said something. So I don't mean to contradict Ed. Weber and Johnson were already not true to the text of Title VII, but part of the blame, just has to, almost go to society, which puts up with these things.
Yeah, I agree that argument was a little bit of a stretch. Regarding that question, there's one more question, and it's something I just want to give all of you guys the opportunity to address, and also you can add in any final closing thoughts you may have. But how this may influence how future administrations or this administration, depending, vet judicial nominees. I think that's something you guys should each address, considering we've gotten a lot of shame on you for enabling Gorsuch type rhetoric recently, as if there's some sort of litmus test regarding this issue.
Well, a lot of the vetting process, sort of goes in the opposite direction. Typically there's a small number of appeals court judges, not always just appeals court judges, but potential nominees who the conservative legal community thinks are both smart and, and principled. And then most of the vetting is to find out, obviously, I mean, there's character type vetting, but most of the vetting is to make sure they haven't said anything too conservative and controversial, that will be used against them in their hearing. So, I don't know if we want more of that type of vetting. But again, at risk of repeating what I said earlier, all the vetting in the world is not going to give you a perfect justice. We wouldn't even agree on what a perfect justice is. We wouldn't want a justice that always rules the conservative way, because sometimes the text or the Constitution doesn't point in that direction. And everyone makes mistakes. If we could have a justice where we were happy with their reasoning, 80, 90% of the time, I mean, I think I'd be pretty happy with that. And again, we don't know, there's a lot of pressure being on the Supreme Court. I don't mean to defend it, but I think everyone knows that being in that bubble tends to push people towards the left. I mean, that's why we've seen GOP nominees drift towards the left, not all of them, but many of them. Look what's happened to Roberts. And Roberts, I think, most of us in the conservative legal community thought great pick at the time. There were a few people who disagreed. Ann Coulter was one of them, if I remember. So unless you have a crystal ball which tells us how these people are going to evolve, I don't know that we can do a much better job. The left can do a much better job because because they believe in results-oriented judging. So if you pick someone with a solid liberal judicial philosophy, they will give you the results you want.
I think it's going to be very difficult to do anything fundamentally different from what we've done. I mean, one can look back at what we might regard as successes. I would certainly put Justices Scalia, Thomas, and Alito in that category, and try to figure out what went right there versus what went wrong. I'll say that on the Alito nomination, there were very powerful conservatives in D.C. who were trying to block him from being nominated in the first place after the Harriet Miers nomination collapsed. I'm not going to go into the details here, but it would be, the infighting that happens, a lot of it ill-informed, is just stunning. So social conservatives, a category that which I include myself, are going to be very distrustful, but social conservatives have also been among the least adept, the least informed in pursuing what they want. We got, Anthony Kennedy after Bork, in large part because of unreliable vouching for how, supposedly, pro-life he was. As with any failure, there's a lot of blame to share, and a lot of us can look back and wonder what went wrong, but I just don't see how things can be done in any fundamentally different way.
Ed mentioned pro-life. We will get very soon a decision in the Louisiana abortion case, and I think that'll tell us more. We already know that on issues of political correctness, high-profile ones, Roberts tends to go the wrong way, and I think people now suspect that may be true of Gorsuch. Again, I think it's way too soon to conclude that, but let's see how they vote in the abortion case. June Medical Services, that'll probably tell us more about how badly the court is broken.
And all justices do make decisions that aren't so great from time to time. I mean, with Scalia, for example, you have Chevron, that he later regretted, not nearly as controversial, and the media, there wasn't as much outrage at the time or now, because that's a completely different topic. But in hindsight, there are always some cases that are wrongly decided.
Well, Scalia was a defender of Chevron, but Chevron predated him. It was a Stevens opinion from 1984, I believe. But nonetheless, I take your point, and again, as we're all we're not going to have agreement among the four of us as to what makes a really good justice, and so we're inevitably going to be disappointed by some of what they do. But that doesn't make, to my mind, it doesn't make any less shocking what happened this week.
To clarify, I meant his reflections on the case, but yes. Okay, with that, I think our time is up here. I'd like to thank all of the panelists for coming out today. I think this is a really great discussion. So thank you. And for everyone in the audience and the panelists as well, this will be recorded and will be on YouTube later, probably later today or tomorrow. And with that, have a great rest of your week.
Thank you to my fellow panelists, and thank you to Ashley for moderating.
Thank you.
Absolutely. Thank you.
Thank you.